Hello and welcome to Mzansi. We're back again. It is that time of the night where we have to deliver. I'm hoping that you can hear us and you are with us. This is the beginning of everything again. We're back to square one. It's 2024. We're still talking the same language of the case. I'm hoping that for those who took holidays and went home and did whatever that they wanted to do, and just forget about YouTube and focus on other stuff, you got a proper rest, and then your mind is going to be functioning beyond. And for those who never left, were now and then getting drips and drops, as Mnisi would suggest, I guess it's a continuation of what has been happening. Aluta continua. So,
the struggle continues.
yes,
The struggle continues.
we're here. We're here. It's like same as before. Let's like the video, share the video, and do whatever that is necessary that you normally have to do for this video to go to numbers that we normally reach. And we're grateful for that. It's through your contributions.
It's about reaching a wider audience.
Yes, it's through your contribution. It's through you who's making us work this hard. Now, the court begins.
Yeah, trial resumes. Court is back in session. Yeah, big new one namhlanje. And we'll just go through some of the stuff that happened. And yes, later on, hopefully we can open the line so that you guys can call in and tell us what you thought about today's proceedings. But I would like to quickly go through some of the stuff that was happening. And guys, yes, this is Mzansi reality. The train is moving again, okay? Thank you so much for joining us. And thank you so much for engaging with this case. We are learning a lot, I must add. We are learning a lot about the tricks and the twists that can be done, you know, and it's very interesting testimony ga Gininda. It's one for the books. That is why no matter how tired I am, we had to be here and we had to dissect what we heard in court today. So the court was adjourned last year after Advocate Tulani Mngomezulu for accused number 1 and 2 was unable to proceed due to ill health. Mngomezulu was busy cross-examining the witness and lead investigator Brigadier Bongani Gininda. The legal teams met with presiding judge Ratam Khwatleng, and it emerged afterwards last year that Mngomezulu was not feeling well. The state started by apologizing for the late start, saying that it was because of the delay in the arrival of accused number 2, Bongani Ntanzi's arrival for issues that had to do with his booking out of prison. So the state also introduced an updated list of exhibits. Exhibit XX, which is an SAP 310-4 regarding interview with the suspect. It was handed in at a request of Advocate Nisi. So I'm going to presume or speculate that this is the confession statement or the statement with regards to Advocate Nisi's client, who's accused number 3, Mncube. Exhibit YY, a letter from LPC dated the 5th of May 2020, confirming the enrollment of Mr. Dominic Mjiako as a legal practitioner, which was received by Brigadier Gininda from Mr. Mjiako at the Pretoria North Police Station on the 23rd of June 2020. Now, this was a day before Ntanzi did the alleged confession. Brigadier Gininda was back on the stand, and the judge asked Mr. Mngomezulu if he had recovered, and Mr. Mngomezulu confirmed to the court that he is fit to continue with the cross-examination. He said that he is fit emotionally and physically and all. And Mngomezulu resumed with cross-examination of the witness with a focus on the warrants of arrest. Mngomezulu started by asking Gininda about the J50s, the warrant of arrest of accused 1 and 2. Asked if he's aware if the section is governed by Section 43 of the Criminal Procedure Act. He said yes, he's aware. And Mngomezulu asked, was the applicant brought to you by the state or the prosecutor? And Gininda said that he had explained that there was an indictment. After the indictment, he made an application at the Boksburg Magistrate Court based on the indictment by the North Gauteng DPP. So Mngomezulu asked, this affidavit is clear that it is in support of the application for the warrant of arrest. And Gininda said it is for the application of the J50s for accused 1 to 5. So Mngomezulu asked, so it is your evidence that all 5 accused before this court were arrested on the strength of the J50 warrant of arrest? And Gininda said, yes, it is. When looking at the provision of Section 43, it relates to an application to be brought before a magistrate. Such an application is to be brought before the magistrate at which the alleged offense was committed. Do you agree? Asking Mngomezulu to Gininda. And Gininda said that he does agree. Mngomezulu asked, so in this case of 636-10 of 24, it's common cause that this incident happened in Vosloorus, and Gininda said yes. And Mngomezulu asked, and you also have courts in Vosloorus? And Gininda said yes, we do, but Boksburg is. Just before he could finish, Mngomezulu interrupted him to say, sorry sir, can I please, we are not in a lecture room. Can you follow my question? Because there are technical issues that I am coming to raise here. I am saying that it's common cause that this offense was committed in Vosloorus. Is that so? And Gininda said, my lord, I agree with that, but I would try I would try to not mislead the court. To try and mislead the court and create an impression that Boksburg does not fall within the jurisdiction of Vosloorus. That is what I wanted to clarify. And I think Mr. Mngomezulu knows that. So this was kind of condescending in a way, but you know how it goes in the court. You just fly over it, creating an impression that Vosloorus is a district court and Boksburg is a regional court within the district of that area. So there's nothing peculiar or unlawful that was done there. That's Gininda saying that. And to me, in my opinion, I think what is peculiar here, and the question for most of us here, is why not start at Vosloorus court first? The depth of the case is at the police station with Vosloorus, the Vosloorus police station, the Vosloorus court. Why not start there? And if they were corrupt, or maybe some corruption happened in between that interfered with the case, then where is the evidence of such that you had to bypass Vosloorus court and immediately go to Boksburg court? That is the question that I have.
Yeah.
And then Mngomezulu asked, do you know the rules relating to demarcation in terms of jurisdiction? And Baloyi stood to object, saying that they don't see the relevance. The judge asked Mr. Mngomezulu, where are you going to? And Mngomezulu said that he's going to the place where this application was brought, in the High Court, unless if you want to submit that this case was unlawfully transferred from the regional court to the High Court, but now we are in the High Court. And Mngomezulu said, I'm not relating to that. The sequence of my question relates with Section 43, and it must be understood by the accused persons that before this court, to say that when I'm dealing with this issue of jurisdiction, I'll just demonstrate to the court that this application has been brought before the wrong court. Right? And the judge said, okay, fine. Then Gininda said, I disagree. It's the same jurisdiction. I think understanding of Mr. Mngomezulu is absolutely wrong. And Mngomezulu said that he'll leave it for argument, but he still maintains that the magistrate court of Vosloorus as per section 43, directing this person should be brought before a lower court, and it was referring to the Vosloorus court where the offense was committed. Gininda then said it's the same jurisdiction, my lord. That's the point that I'm saying. That's why the SPP of Boksburg is the same as that of Vosloorus court. It's the same SPP. That's why one SPP, including the control prosecutor. So it's one in the same. Only in Gininda's world is a district court and a regional court one in the same. You know,
Yeah.
only in his world.
In his world only.
Yeah, it's the same, and he keeps emphasizing that it's the same SPP, it's the same control prosecutor, but it's not the same jurisdiction, is it not?
No, it's not. It's not.
Mngomezulu said that he will reserve it for argument, okay? Then he said, let's get into the requirements that a peace officer or the commissioned officer who is to execute the warrant, that the person must have a reasonable suspicion that an offense was committed. He asked Gininda, you are aware of that, sir? And Gininda said, yes. Mngomezulu then said, in terms of your evidence, you brought this application or warrant of arrest in October 2020. And Gininda said that it was the 23rd and the accused were already in custody. So Gininda argued, saying that they have already dealt with that aspect. He said that it must be clear that they were incarcerated for different matters. To try and create an impression that they were incarcerated for this matter is, and just before he could finish, Mngomezulu interrupted to say that, Mr. Gininda, sir, with due respect, I'm not creating an impression. I'm cross-examining you on what is prescribed by the law. I'm not giving my opinion here. What I'm saying is, when you approach the Boksburg court on the 23rd of October, my apologies, 2020, I didn't want to know the reasons as to why they were arrested and who was arrested first. I was saying that all the 5 accused were already arrested and they were in custody. Is that so? And Gininda said, for different matters, yes. Mngomezulu then said, the application that you brought on the 23rd of October 2020, if you understand what it is, it's a warrant of arrest. It talks about depriving somebody of his liberty. Do you agree? And Baloyi stood to object, saying the insinuation that if Brigadier knows something about a warrant, we find that belittling and it should be withdrawn. Mngomezulu said that he differs with his learned colleague. And he said Brigadier Gininda is a very experienced police officer. The reason why I ask about Section 43, you can't do things because you have done it and you don't do it according to how the law prescribes. If now, before he could finish his statement, the judge interfered to say so, and Mngomezulu asked to address it further with due respect. Now, this is where the tussle was beginning to happen, okay? Hi, Judge Rata. Well, then the tussle was beginning, it was warming up. Mngomezulu asked to address it further with due respect. He said, if Brigadier was able to, at the time, to distinguish how warrants are issued, and to him, when he brought this application, he fully was aware, because this is what the provisions of Section 43 and the case law requires, that he must exercise an independent opinion. Hence, his capabilities are expected when bringing this application. He said, I cannot bring bail application not knowing what are the tests for bail application, what are the reasons for the refusal of bail or the granting of bail. My submission is that in terms of what is required by the provision, especially case law in Maposa's case, it reiterates the aspect of an independent opinion to be exercised by who? by the commission officer who is executing the warrant of arrest in terms of Section 44 of the Criminal Procedure Act. He must answer questions relating to the application that he brought relating to the arrest of these people. The judge started by saying that he was not interfering. Mr. Brigadier Gininda said that you say that you and him have a different conceptual understanding of Section 43. And then he asked for this Section 43 to be read, okay? The state, Mr. Baloy, stood to read, and he read it. He said the heading is warrant of arrest may be issued by magistrate or justice. Subsection 1 of Section 43. Any magistrate or justice may issue a warrant for the arrest of any person upon the written application of an attorney general. Now the Director of Public Prosecutions, which is the DPP. So before they used to call them the Attorney General, but now they are calling them the Director of Public Prosecutions. A public prosecutor or commissioned officer of police. A, which sets out the offense alleged to have been committed. B, which alleges that such offense was committed within the area of jurisdiction of such a magistrate, or in the case of a justice, within the area of jurisdiction of a magistrate, within whose district or application area is made with the justice for such warrant, or where such an offense was not committed within the area of jurisdiction which alleges that the person in respect of whom the application is made is known or is of reasonable ground suspected to be within such area of jurisdiction. And C, from information taken upon oath, there is a reasonable suspicion that the person in respect of whom the warrant is applied for has committed the alleged offense, notwithstanding any other application for a warrant under this section in respect of the offenses listed in Section 21, subsection 1A to D, may be made to any magistrate or justice, irrespective of whether or not the place of execution of the warrant or the place where the alleged crime has been committed falls within the jurisdiction of such a magistrate or justice. So basically here they are saying, or it's sort of like trying to support what Brigadier Gininda was saying that the SPP is the same at the regional court of Vosloorus as the other court, the Boksburg court. So this was attempting to support that. But now he was speaking of the SPP, right? And this subsection, what is talking about the DPP.
Yes.
And the DPP is head of all regional courts within a region.
Yes,
right?
that's true.
So what is happening here, Mr. Ranabas? I don't know if you caught it.
No, I did. You know, that's the thing. And what I'm hearing, many people are saying that the guy is smart because he speaks
good English. Yes.
Fluently. It's not even good, it's fluent.
He speaks fluently.
So just because people are just hearing that movement subsequently,
big words.
he's using subsequently, he's using a lot when he wants to add. Well, what I can say is that if you listen to him, he says a lot of nothing.
But people are convinced
No.
that he's saying something
No.
I'm exhausted. He's exhausting me.
Yeah.
I'm tired of his testimony. I just, I feel like at this point a decision has to be made because we have nothing so far. So far, it's like he doesn't answer questions, my people.
Yeah, he just he has information about law. It seems as if he has studied law 101
and working how he works
from the beginning. Maybe studying, something lawish, and then he's trying to impose
what
that
he
knowledge,
knows.
what he knows, compared to someone who's practicing.
Mm.
You understand? And that's where the problems. That's why today, later on, you'll hear from the issue of docket, where clearly he does not have the docket, the main docket.
Nongoma.
Nongoma one. They sort of, to me, it sounds like they created their own docket.
Wow. Are you
No, I'm saying their own in a sense of this whole secret cases that when you count them, it's only 3 of them. It's only 4. I think it's 3 of them. It's the one of the ammunition that comes from them. It's Nongoma one, which they are not sure whether it's murder or unlicensed firearm. And then there is an issue of Senzo. That's another one.
Yes.
And then I think the issue of there was no allegations of drugs or something like that.
Substances. Yes. Illegal substances.
Yes.
Yes. So that one as well.
Yes. So
and ammunition.
Yeah. That's basically, those are the cases that they're talking about, which comes from them in a sense, except for Nongoma. Then they created this centralized docket of theirs, in a sense, which looks like they're trying to bypass the real docket of Nongo.
Oh my God.
Obvious. This is my own perception. That's what I heard.
The thing about the Nongoma case is that
I knew they were not going to get the case.
He does not even have.
I knew they were not going to get the docket. Yes, I knew they were not going to get the docket, because what happens in KZN is totally different from what happens in Joburg. You can be in charge of Joburg, but less in charge of KZN.
Different jurisdictions,
but
right?
we obviously still going to discuss that. I was just giving you the examples of what you need to look at.
But this was very interesting about how they tried to support this SPP thing of his, and they brought out a textbook and started reading, and I'm like, okay, but it's not the same thing from what I'm observing, so an explanation was necessary. Well, the judge asked, now, what is the problem after that whole reading? Because to him, I guess it's the same thing, or it elaborates what Brigadier Gininda is saying. By the way, why is Brigadier Gininda's testimony all of a sudden supported with textbooks? The other witnesses, I don't remember their testimonies where we have to whap out a textbook and make sure that what is being said is what's up with that, And the judge said, what are you saying Brigadier Gininda did not do in pursuance of section 43 subsection 1, so that we all know the dispute? Mngomezulu said, I'm trying to run away from the witness saying that I'm creating an impression. Let's just put it straight. A warrant of arrest deals with somebody who is not in custody. And the judge said, no, that is not how I understand the law. He gave an example and said that if I kill somebody today, an inspector, Nisi, arrests me and puts me in custody because he's got evidence that I killed somebody. After 3 weeks, Inspector Nisi here comes. He has killed another one in Klipspruit. And he said, I'm inside. He goes and he fetches another warrant of arrest in respect of that other one. What's the problem then? And Mr. Mngomezulu said, I'll differ with the court here. I'll make submissions as well, because there's also a procedure in relation to requisition of a particular suspect or an accused person. Hence a scenario in terms of what the court is now making. It's relating to the meaning of what is arrest, because the logic on this application, there is somewhere in this provision that says a person is reasonably suspected to be residing somewhere, but when an application is brought by an officer who is fully aware that this person is not in Tembisa, that this person is in Moda Bay, is clearly a misinterpretation of facts, because if you look at the J50, it does bar the address where the suspect is at the time that the application was brought. Lest we actually not forget that the illegal substance case was for Tembisa, right? Then how did he end up in Vosloorus? Because that's what he was initially arrested for. Okay, fine, he made the confession on the same day. But the illegal substance matter was in Tembisa.
Yes.
So Gininda said that for accused number 1, he said that the address was unknown based on the events that were unfolding at the time. So here you are. He's making it sound like they initially arrested him for the Senzo Meyiwa case.
So,
and that's not the case.
So perhaps let's look at key aspects that warrant of arrest deals with. It's a probable cause. So in this case, before a warrant is issued, there must be a probable cause, specificity. The warrant of arrest must specify the identity of the person to be arrested and provide details about the alleged offense.
Okay.
Authorization for the arrest. The warrant of arrest, law enforcement officer to arrest the individual, it empowers them to take the person into custody. Execution, law enforcement officers execute the warrant of arrest by locating and apprehending the individual named in the warrant. The court appearance, now this is where I think where they were hindering. The court appearance. Once an arrested person is typically brought before court, the court will inform them of the charges against them and they may have the opportunity to defend themselves. So he's saying he was using a warrant of arrest just for that. Then the last one is obviously judicial oversight. Warrant of arrest are issued by a judge or the judicial officer. This ensures that there is a level of judicial oversight in the process, helping to prevent arbitrary or unlawful arrest.
Okay.
Yeah, so the only reason why he's saying we issued a warrant of arrest while someone was in custody is because he wanted to, they're claiming it can be used just for court appearance. So that the person can be used, it can be. This is where Mngomezulu was arguing. Typically, once a person is already in custody, there is no need for separate warrant of arrest. Warrant of arrest is generally issued by the court or the law enforcement authority to authorize the arrest of an individual who has not yet been taken into custody. When someone is already in custody, it means that they have been apprehended, arrested, and are being held by the law enforcement or other authorities. In such cases, the legal process usually involves charging the individual, and they may be brought before a court for a hearing or a trial. That's what Mngomezulu was arguing.
So he was trying to argue that
there was no need for a warrant of arrest.
Because they would
Because
already
according to them, they are saying
incarcerated
they already incarcerated him for a Nongoma case. But
was it even Nongoma case or the illegal substance?
No, it was Nongoma case.
It was the Nongoma case.
The illegal substance is fading, actually. It is fading. We're not dealing with it right now. We're only dealing with the Nongoma case, which they are not even sure whether it includes murder and what we call it,
possession of illegal firearm.
They are not sure as whether murder is also included there. Apparently or allegedly, it was just possession of unlicensed firearm. That's why the question was asked. What of the murder, as you have written down here, the murder? And then the answer was not clear. someone else is investigating this. Yet, as much as someone else is investigating this, you are in charge of these people. You said you know all these cases that they deal with. And now you are confused about the case that is connected to how you actually apprehended the accused for the main case that you are investigating.
And Kininda said that he's not sure whether Mr. Mgomezulu is insinuating that a prison is a residential address, because it clearly asked on the J50 on the warrant the address, which is a residential address. And he said you cannot now put a building, correctional services, as a residential address. He said he's never seen that. Because
they are going to fail to defend this warrant of arrest issue, because seemingly there was no need for it. So you couldn't have written the address because there was no need for it. The person that you were looking for or wanting to arrest was already in custody. So how then do you issue another one and say something else? So now they are defending the situation that shouldn't have happened. Obviously, one can argue that it does happen. I don't know. This is South Africa. That's a problem, South African law. It always learn new things are accepted. If this is the first time this is happening, then it's one day it's going to be referred to as
someone else is going to use it. Yes. Someone else is going to imply it and use it. Yes. And Gomezulu said, Mr. Kininda, you don't even understand yourself. Listen to this. I felt this shade. I felt this jab. And the reason is because I seem to be very annoyed by Kininda. I'm annoyed by the over-explanations and the long lectures, and it's annoying. Some questions are very simple. They just need to be answered with one sentence. And he decides to write the whole history book and still not give an answer. Yeah. It's amazing. It's an amazing skill. Yeah. So on the 30th
answering
of May,
without answering.
Yes, it's an amazing skill. It's beautiful to watch. But however, I'm impatient. I want to know what happened in that house on that night. I want this case to reach some form of a conclusion, and it must be a fair one, not a one that doesn't make sense. Okay. So on the 30th of May 2020, first time you met Sibia in Vosloorus, you were alleged.
And Emil, it's true. Someone is adding. There was a feeling that because of that missing address on that warrant of arrest, then it also disturbed the issue of how can I say this? The issue of this person, Danzi, being released on bail. Because they claim that they did not know
where he resided. He gave them a wrong address. So yes, it did interfere with the bail.
Yes.
That interferes with the bail. They need to confirm your place of residence. That's one of the conditions that are very important for a bail application. And it's being filled out wrong, and they are insisting it's something.
It is crazy though, because if you think about it in that manner also, what makes it even more crazy is that if they claim that the case of Nongoma is the reason why that guy was there at the first place, why then, while it's still on, according to them, why then did they allow a bail hearing? Because either way, you were not eligible for bail if you were arrested for, or if you were in custody for a different case. Yes. The bail application was for Senzo's 363.
636.
636, yes. So why did they allow to go through that process?
It's a very interesting, ne?
Yeah.
Because if you are incarcerated for something else and then you appear for bail for the other matter, and in that other case you are incarcerated, it just doesn't make any sense how things are happening with this case. It doesn't make any sense. Nothing makes sense. So he also said that in Vosloorus you allege that he made a confession. That's your evidence. Immediately, spontaneously, you look for someone who can take the confession, and you knew at the time where was Bia kept. But that's not correct. On the 30th, that was the first time accused number 1 was arrested. As so far as the illegal substance dealing matter, that was the first time he was arrested. It was before he was incarcerated officially. In other words, being detained in the holding cells. Yo, Gininda over-explains stuff. And speaking of the illegal substances case, he was not charged for dealing in that matter. No, now that they are distancing a bit from that illegals, and the funny thing is that it should be something that I thought they would use because it has a sentence, right? It's been concluded, but the distancing now we are at Nongoma case now. Like
no, that's accused number 2.
Oh, so that's for accused number 2.
Yes.
All right. So now we are on accused number 1. And the illegal dealing substance case, he did get 5 concurrently, 5 each for possession of illegal substances. By the way, for those who don't know, it was 0.7 grams. Somehow it managed to be 10 sachets. That's what he was charged for or with. And it was 5 years, the sentence that he got for that. And then for possession of ammunition, the one that was found in the black plastic bag as they were arresting him for the Senzo Meyiwa. Yeah, that one, 5 years as well. So they're going to run concurrently. So, and my lord, he said, the issue of getting a counsel suggests that I've made arrangements spontaneously for someone to obtain his confession. This is Gininda now defending himself. That is the best practice. You try and get someone independent to document the confession. It is done that way so that there is no issues of compromise or having interest in the matter. That is how it is done. There's nothing spontaneous about it. I don't want to rush you, and that's what Ngomezulu responded. I don't want to rush you, and I don't want you to rush me. I'll get into that aspect of how to take a confession, but my concern is when you met Sibia for the first time, you questioned him to the extent of explaining his constitutional rights relating to this case. I'm not talking about the illegal substance charge. I'm talking about the Senzo Meyiwa murder. You allege that he made a statement and immediately you took a decision that this person is confessing. Let me do the formalities. My concern is when Sibia was already arrested on a J50 by Sergeant Mogola, he was already under arrest. So Gininda then said, I don't understand, what is the question, my lord? Ngomezulu said, let me repeat it for you because you tend to explain things that you don't even understand yourself. I laughed because if there's one thing Gininda will do is explain Shem. Give a lecture and a lesson, Tagabao. Even if what is required is just a simple yes or no, he will have a whole history book as an answer.
Yes.
So when Sibia was arrested on a J50 warrant of arrest applied for by Sergeant Mogola, when he was brought to you on the 30th of May at Vosloorus, he was already under arrest. Then Gininda said, my lord, just before he could finish, Balo stood to object to say that he feels that counsel owes the witness courtesy in cross-examining him. Now, to say that he explains things, he doesn't understand. He thinks it's rude and overbearing.
Yeah, man, Gininde has been rude too.
But somehow that is not picked up. That is never picked up when the witnesses are being rude instead of answering questions.
Romanticizing this guy, man. I don't understand why, but yeah, I guess it's big.
Mngomezulu then said, I'm glad if my colleague can pick up that. But if that is done by the witness mistakenly, I've uttered words. You read the rights of the accused. Out of insinuation, he said, I didn't say that. I will take him on the attitude he wants me to address him on. But as long as it's going to maintain the decorum of this court. Which is quite interesting. I mean, when he was busy saying that Mr. Mngomezulu is insinuating, nobody was saying anything. Everybody was just quiet. And now that Mr. Mngomezulu also throws in a bit of shade, nae, it's rude. It's now rude.
And it will be
overbearing.
attended to. Yes.
But as long as it's going to maintain the decorum of this court, Mngomezulu said, I am going to prove before this court that when this application was brought on the 23rd of October, it was unlawfully obtained on the 23rd because this accused person was already in prison. What is of pivotal importance here is what do you submit as facts to the magistrate who is going to issue that warrant. If the address appears to be unknown, obviously in the mind of the presiding officer will say it must be circulated for this person to be arrested. Mngomezulu argued that the warrant of arrest for the accused in October 2020 when they were arrested for the Meyiwa murder case did not reflect the accused address, which he says was unprocedural. The judge reiterated that Mngomezulu and Gininda were not on the same picture or on the same page. He said, Mr. Mngomezulu, that otherwise we are going to be here until Mandela is resurrected. So he was throwing shade at Mngomezulu that he's taking too long to make his point because Gininda was not understanding. And Gininda not understanding is of his own doing because he doesn't listen to the question and he gives answers that are too long.
Yeah.
So the judge said, why don't you put your version of the law, what you are arguing to say, then let the witness respond to that. The judge said that he remembers Gininda telling the court, what Kalafuti? He started with that thing of speaking on behalf of the witnesses as if he was there. He was fagazeling for Gininda now. He was telling the court that they went to check at Kwanongoma and he was not there. Judge Rata started again with that whole thing he does of defending the witness by adding that he left them in the cells and went to Nongoma, and then he went to Nongoma to a particular address, and they said they didn't know the man.
Which is wrong because he went with them.
Which is wrong. Gininda corrected him. He said, I actually went with him. We booked him out. And they said they know him, my lord. The people at Nongoma said they know him. Can he stop with this already? We are tired.
What is of importance is that the theories of these guys, they seem to be, I would say, affirmed by those who are telling the story but telling it different. The issue of them going to KZN and the families talking about it, saying that they came,
yes,
and they said 1, 2, 3, and the guy is not denying that, but he's saying he was there to confirm and address. So now you listen to these two stories. It's a confirmation of an address. When they found ammunition, it was different stories. What was it? Is it the issue of changing the pens, and then from there it was the issue of making sure that the address was the correct one.
Yes.
Looking for an ID. The theory just it twists a bit.
After checking
whatever that the guys are
the
saying,
correct one, they still got it wrong.
Yes. whatever that the guys are saying, we went to KZN, we talked to our families, we told them what was happening.
Yes.
The family affirming that, saying that, yes, it did happen.
Yes.
Then it is twisted now. It's an issue of looking for an address. Now, the question that I have is, they did that with Dance. How did they confirm the address of others? Because they are not from the same place. Did they go to their homes? All of them.
That is a good question. A very good question. I would like to know. Did they also confirm accused number 3, 4, and 5's addresses?
I don't know.
Well, the judge, Mngomezulu, said that he wanted to request that the court be impartial after he threw that shade about Mandela being resurrected and whatnot. It was very weird. The judge said he's impartial. The only thing that he's doing in this court is quoting the law as he understands it. That's all. But he also testifying on behalf of the witnesses. Why can't you just let Gininda speak for himself? I mean, he has no troubles expressing himself, Mos.
He knows English.
How? Mngomezulu then said, after the examination of Gininda, I'm going to bring an application under Section 317 for a special entry because what I have picked up during or seemingly Mngomezulu's perceived impartiality on the court's part, he wanted to bring up that application. Well, Gininda said that he doesn't believe that he treated Mr. Mngomezulu with disrespect. He said that there's no need to get emotional on this. Let's just do the business of the day, be professional about it, and move on. This was interesting to me. Why does it seem like you want to stop him from making the application? Some of us want that to happen now. It's too much.
No, they should do it.
It's too much. What the judge is doing is extra. There's no way.
They should do it. Yes, today he was a bit calm. What worried me is that what was said by Chief. Who? Is it Mlambo?
Oh yes, Chief Justice Mlambo.
Chief Justice Mlambo.
Is it Chief Justice or Justice? I'd like it.
I think
it's Justice Mlambo.
Justice Mlambo.
I think.
Yeah.
Or Judge President. No, it's actually Judge President Mlambo. My apologies. These titles, they yes, what he said was very troubling. But then Gininda explained that there is nowhere in the law where it says when a suspect is already in custody, he cannot be arrested. Gininda also said that the charge of premeditated murder against the accused required that warrants of arrest be issued even if the accused were in custody at the time. He also said because of the nature of the charge, even if they weren't in custody, a premeditated murder charge is not a charge the suspect could just be warned about and told when to appear in court without the accused being arrested.
But the accused is in custody.
They are held in the jails. So where were they going to run to?
Nowhere.
Where were they going to run to?
It was unnecessary.
It was extra, ne?
Hey, it was extra. It was
but
unnecessary.
Then he defends it. He's defending it for dear life. And he's saying, show me the law. Show me the law. Let me get into it, Mr.
The law does not necessarily say it should not happen.
What does it say?
It might with other people happen. I guess this one is one of those. It might, but honestly, there is no need. That's what the law says.
So Mngomezulu then said, did you ever mention in your affidavit that accused number 1 or number 2 was arrested for another offense? And Gininda said, I'm not sure. I'll have to refresh my memory. It was in 2020. And then he went on and on, blah, blah, blah. And he said, as to that, I need to go back and read my statement. The application was not about the verification of the addresses. It was about the evidence that he had. Mngomezulu then said, let me just put it to you that if you brought an application and the state clearly in your affidavit that accused number 1 was in Modabi and accused number 2 in Pukeng as an example, the magistrate court was not going to grant that application for warrant of arrest. Gininda said, no, I do not agree. That's not true, my lord. Can you please show me where it states that if a person is arrested, a J50 cannot be applied for? Then perhaps we can close this matter because I'm not aware of such. Mngomezulu to Gininda said the full details.
In all logical form, there is no need for J50. Because the main aim of it is to make sure that first you are aware that there's a charge against you.
Yes.
And 2 is to make sure that you are aware of the dates where you need to attend the PN court. So if you are in custody, all that is covered. And only one thing that is missing is for you to for them to let you know that you are now charged for something extra.
And perhaps read your rights. That's it.
Yes.
Okay, no issuing of J50. That was overkill.
Just doesn't make sense.
The full details were not disclosed to the presiding officer, but Loy stood to object and said that it's an unfair question. Then he read a section talking about summons. And as you know, the judge in the state agreed. Okay, and Mngomezulu said that he'll get to the part, even if what Gininda is saying, that there is no such law, you know. He said, my concern is when the application was brought, there was information that was not disclosed fully to the presiding officer. And Gininda said the address, how is it relevant to the evidence? What the presiding officer and the prosecutor, who both of them signed the warrant, needed to know the strength of the case, whether such a warrant can be authorized, and a decision was taken based on that. He still wanted the section of the law that says that without an address, a warrant cannot be issued. He went on and on and on and on. Well, a warrant of arrest are none of the means to bring people to court. So it initially appeared that it was a robbery gone wrong. This is now reading from the witness. Was it the statement, the affidavit that Brigadier Gininda had done? The highlight of it is that it initially appeared that it was a robbery gone wrong, and witness statements under oath indicated that 2 black males entered the house demanding cell phones and money. 7 adults and 1 child were present in the house when the accused entered. Excuse me. And the witnesses stated that one of the accused was carrying a firearm purporting to be a revolver. A revolver is very interesting.
But the choice of words, the choice of words, they're purporting, which seemed like a revolver. So now they are not saying it could have been a revolver. They're saying it now seemed, according to what Gininda wrote down there.
Do you think this was to cover himself? Why am I saying that to cover himself? I'm thinking of the many instances where the revolver has been squashed, debunked, taken out, and Mthokozisi even steps back to say that no, it's not. Who was testifying with the revolver? Was it Mthokozisi's statement initially allegedly had a revolver in it, and now it backtrack? It was not. I did not see. I only saw the hole. I only saw the front part. So, and then going back to the scene as well.
The problem is that if it's a revolver, it's not gonna be able to match with the cartridge and everything.
Cases that were found on
that
the
was
scene.
the problem.
So if we had let go of the revolver, right? And now he's bringing it back in his affidavit.
It was not gone, because what they did when they obviously this is alleged, they sort of brought now 2 guns in question to say that it could have been the other one. Because the question of revolver was throwing the case out. So it could have been just another one because they had two.
Witnesses stated that one of the accused was carrying a firearm purporting to be a revolver. This accused was described as a black male with dreadlocks, big eyes, wearing a khaki or brown jacket and a top and a hat. He was shorter in height than the second suspect. The second suspect was described as a tall, slender, neatly shaven and dark in complexion.
Fitting.
It is the state under oath that during the robbery in the same house, a struggle ensued between Senzo Meyiwa, the deceased, and the suspect carrying the firearm. 2 shots were fired by the suspect.
2 shots?
2 shots.
Not 3.
Type saying. Lorraine as well testified
not
3.
2 shots.
Did Gininda even interview the people that were at the house? Because he's at Boxback now.
I doubt.
Why didn't he go to the beginning? Why didn't he speak to the people at the house so that his case is a bit stronger? But no, it seems they only spoke to
the other
Zoom.
one who was looking for
allegedly
cell phones did not have a knife now.
No.
Or some weapon or something.
No, there's no knife. There's no mention. Hey, Lorraine. Mo. Kareke matata iso. Hey. One of the gunshots hit the deceased, Senzo Meyiwa, on close range in his chest and exited at the back of his body. The second accused focused on the rest of the witnesses. In the process, one of the cellular phones belonging to Ms. Kelly Kumalo was robbed by the suspects during the committal of this offense.
You know what would have been interesting?
What?
Let us say we take that theory of a cell phone that was taken. Let's say we accept it. Now, you are an investigating officer that is investigating the case, and you want to make sure that you have all the things that are going to put this guy to jail.
Yes.
This guy is confessing. Why didn't he tell you what happens to the phone?
With the phone.
Why are you using the network, internet, the towers to tell us where it disappeared? Unless, of course, if there's no cell phone that was taken. I mean, the guys are confessing. They should tell you everything. The phone, I sold it to my friend there, or something.
No, or I threw it in the river.
Because that is evidence that you're going to need, that is going to link those guys. Yes.
Where is the phone?
And one thing that is making me ask this question is that eventually we are saying that the phone was never found again.
Yes, it was never found. It was also stated under oath that the suspicious suspects wearing specific clothing, among others a hoodie, were hidden, standing away about a few meters away from the crime scene prior to the incident, appearing to be typing on their cell phones. This was an interesting time, appearing to be typing. Here are these people. They are supposed to be performing a hit. These are Mncubes, and they're typing on their cell phones.
And on that confession, what would be interesting is, who did these people say was the mastermind? And the question again goes back to, why is that mastermind not here?
Not in court, sitting where they are sitting with them. Why?
Do you understand? Like, if you look at the case of Nandipa, the people who are alleged to have allowed assisted Baxter, they are there sitting with him.
Yes.
Even his Nandipa's father is there.
Yes.
Why do we have these 5 sitting there? But the case, according to this investigator, who's very smart, says that it screams that it was a hit Why are they not there?
Now we know where the utterances by Gerinel come from. We are going to speculate that he saw this.
Obvious.
So it is stated that the suspect fled on foot and the hat which was worn by the shooter was left on the crime scene. It is equally stated that the suspect...
Now, do you see that theory on its own? It's crazy. There is a driver which is now, we are hearing that the most probably dangerous hitman was a driver today.
The one who doesn't send, who does it himself.
Yes, allegedly.
Allegedly.
Was a driver. The one who you would want inside if you were to do something.
Was driving.
Was driving. And two, they were chilling outside dealing with phones. But these people, they ran on foot. Then if you come with that theory that the car was parked there by the park, then who was watching for people not to come in? As we are saying, Mapisa was watching for people not to come in, and the other one was waiting with the car. They were all on their phones. And then there's a theory of these women, Memang,
and type saying,
who saw two people running.
Mapiri.
Then the other ones, what did they do? No one saw them. No, the three. No one saw what the three did.
And this other car, they didn't see it. What type saying?
No.
They didn't see the silver Polo.
And they were standing outside. Not just they didn't see because they were in the house. No, they were standing, so they didn't see it.
And let's say maybe they didn't
but
see
someone,
it. But
somewhere, somehow saw people on their phones chilling there.
And that person is not known. And on top of that, let's say they got off the park and Tabseng and Mapiri and everyone who was outside did not see these people walking towards the Spaza house. That they were not familiar with. They didn't see them walking down the street. They just came out of nowhere. They were inside the house. But when Tabseng was standing outside, they were outside their yard on the street. They had parked there.
This is
and
crazy,
they didn't
man.
see.
This is crazy. It's like you have, you know what? It's like having Lionel Messi chilling on the bench there. Yeah, playing with Botevez and everyone else.
My question is, why didn't this cold case division investigation start there? That is the question I have. Why utomako box back? Aye. It is equally stated that the suspect hidden away, which is explained to be linked to the offense, was seen running away from the crime scene. Identikits were compiled through witnesses of these suspects, and the victim was rushed to the hospital by the witnesses who were in the house. However, he was declared dead on arrival at the hospital.
You see what is crazy and what I still find crazy even today? Here is Muzi.
Yes.
I'm not sure if I'm going to get this thing right. It's Muzi goes there in, what do we call it, in that hostel of his. Not his, actually, that hostel, which we don't know yet what is the link with that hostel with Fosloras. He goes and brags about what has happened to Senzo. Before it was announced to radio, and he's even saying on that affidavit that he said it before, according to the person who was there.
Yes.
And
he said he checked on his social media in 2014.
I think we now I'm talking about what was written on that statement.
Okay.
Someone was there in that family gathering. It's called family gathering, by the way.
Yeah, now it's called the family gathering.
Someone was there. They brag that Senzo is Shaile. And they don't know. And these people who were in the house, they are saying they took Senzo alive
didn't they?
Until the hospital. That's where he was declared.
No, they said they even went with him inside the hospital.
Eh.
The doctors were busy rushing.
Yeah.
They were trying to bring him, to heal him and to stop him from
So this
passing
guy-
away. And they worked on him for quite some time because they were waiting. And then after some time, the doctor or somebody came and announced. It was like a movie. The way
We are
was
reminding you
describing.
because you might have forgotten.
And
so
now
this guy-
the affidavit is saying
This guy spiritually, after this whole incident, he could feel that this guy is gone. Before it was announced, because he didn't know now, right? He's gone.
Oh, now he confirmed.
He's
That.
confirming already before it was announced.
So why would he confirm that if he was still alive?
That's
at
that's
the
my
house?
question. That's my question.
He was bragging, right?
Why would you brag about something that you didn't finish?
And what's interesting from this affidavit is that he was declared dead on arrival at the hospital. That's why Judge Rata Mkhwatleng was like, it's hearsay. This affidavit, this man, affidavit, guys.
What I hear some people saying that it's an ongoing. Gomez was not supposed to question up to this point where I'm happy that it came out. Because what this thing was doing, it was purporting itself as if there is more to this case through these affidavits that they are fighting against. No, what now we are hearing is a bit of what is there.
Yep.
And with that theory, it still does not match. Still does not make sense. The only thing that you can succeed in creating is a bullet. Obviously, you own everything when it comes to that. We hear what you say. But when it comes to the theory, you can never own a theory, because you must be that smart to create a theory that really links properly.
Or will stick.
That would stick, yes.
So the incident took place between 8:30 and 9 o'clock.
That is being emphasized. By the way, there is an interview of Jwaha,
A soccer fan.
a soccer
Orlando
fan.
Pirates
You know
fan.
Babu Jwaha, those supporters of Pirate, they know him like me. I know him. He was interviewed. What did you say?
He said
About
they
the
got
time.
the phone call. They received a phone call that Senzo had passed on, and he said it was something to 7. That's
We're
like,
going back to that issue of 6.
something to 7. That's when they were getting phone calls letting them know that Senzo was gone. Something to 7.
When we predicted 6 here, it was like sounding like a gullible thing.
They said we were being accused here, and the
Yeah.
game, we still checked it again during the December break. The game happened at 6.
Yes. So the situation could have happened at 6. And in all honesty, if Babu Jwaha and I low phone baggage,
Nkosi yami.
asinikeze wona nje. Check isikhathi nje ukuthi kwakunini nje phela. That's it. When was it? That's it.
The deceased was declared dead on arrival at the hospital at 15 minutes past 9 p.m. The investigation revealed that the cell phone was robbed and was picked up through cell phone towers until the signal was lost, covering the area of the Vosloorus hostel. They said that the cell phone was never recovered to date or ever switched on again. The evidence explained here is under oath and will indicate that the planning of the offense and gathering after the incident took place at the Vosloorus hostel. Investigations which resulted in the evidence under oath revealed that the victim was murdered as a contractual assassination or hit rather than a robbery gone wrong. Evidence also revealed that 5 suspects actively participated in the planning and execution of the contractual killing of Senzo Meyiwa.
Can I ask you something?
Ask.
Has Mjako ever worked with Ginindi? I mean, in the same maybe department? That's a question for another day. Let's continue.
The suspects in question are as follows. Muzaukulelwa Tembas Bia. He was first linked to this offense by means of witness statement under oath. The accused boasted to individuals closely associated with him in KZN homeland. Gininda's affidavit also reveals the alleged role of each of the accused in the execution of the crime. Together with the rest of the suspects, a dispute ensued between the two individuals, and the closely associated individuals disclosed to the SAPS the admissions these accused made to them. The accused was further linked with circumstantial evidence, wherein minutes after the incident made disclosure and remarks at a family gathering he attended in Vosloorus as to the killing of Senzo, even before the death was reported in the media.
So this whole Waka Waka issue, it is clear now that it started with Zungu.
This is Zungu's testimony, this one.
Yeah, and you see what is very disturbing about Zungu's testimony. One, it comes as if he was actually there. At Vosloorus, and not only there at Vosloorus, he was also there in KZN or wherever they were. His father was at. It's as if it's one person who's doing all this thing.
And they're speaking of the father in Nongoma, right?
But they are not actually now. If you listen to this, it's like the one person is actually.
So Kizungu.
It seems as if they aim. And you tell me if I'm wrong. It seems as if when this thing all started, the aim was to shy away from the father being involved. But eventually, for some weird reason, the father popped up.
Towards the end of Zungu's testimony, the father did pop up. And you know how interesting it is, because in 2014, in Zungu's testimony, as he was saying, and then Gwabini mentioned Snako, the shooting of Snako, and Snako passed away in 2017. I still can't get that out of my mind.
Yes, and I also still cannot, even after the whole Dinova thing, get the issue of a car being used that Gwabini was driving. Do you remember that part? As if they did not use the other car, they used his car. And then when he questioned them, they were like, no, we used it.
Yes.
You remember that part?
I remember that part. He said the Gwabini used his car.
There are
and
things
then he
that
was
you
questioning them.
Yeah.
Why did you use my car?
Yes.
What if?
Yes. There are things that when you think about them, in this case, you feel like you were dreaming, but actually they were said, those things. They were there. And I can tell you, most people would not remember that. Some would remember
Some
that.
would. Some definitely would. People are smart out here. He's further linked by formal confession, and he made to the Commission Independent Office on the 30th of May 2020. The suspect further made a formal pointing out to the sequence collection prior to the incident guarding the outside of the house during the assassination and the dropping of the accused at a cell phone tower referred to here in above. Number 2, Bongani Sandiso Ntanzi, nickname Mafika. He is linked to this offense by means of certified statement he made to the witness and the identity kit compiled through description of the witnesses.
So when this thing started,
yes,
it could have stopped if really Warrant Officer Mncube was listened to and said Gwabini was lying.
Not Gwabini Zungu.
Kuzungu. Yeah, Gwabini is Zungu.
Oh, Konje Takazem.
Takazem. So it could have stopped.
Yeah.
But it started there. And then there's a train of things happening here. Muzi is linked through Gwabini as this close associate to the homeland of KZN. This is the guy. Now that's Gwabini. And then Muzi links accused number 2, according to what is said here. Through his evidence and his testimony, links accused number 2.
All
Continue.
right. So he's saying that he was identified as the person with a hoodie who initially stood outside of the house prior to the incident and running away after the incident. The involvement of this suspect was mentioned by suspect number 1. Herein above as equally involved in the killing of the deceased to the family of the suspect number 1. And the suspect was traced through information received, and he was confronted with the evidence available against him. He was among other confronted with the clothes he was alleged to have worn and compiled identikit. During the questioning and the subsequent search of the premises where ammunition was found for which no license was produced. The suspect was arrested for this offense. Hereafter, the suspect indicated his eagerness to confess as to the involvement in this matter. The suspect made a confession to a commissioned officer on the 19th of June 2020 and later made a further confession in the presence of his attorney to a magistrate in Boksburg Court on the 24th of June 2020. Now, isn't it interesting that Mchiako submitted his letter from the LPC to Brigadier Gininda at the Pretoria North Police Station on the 23rd of June 2020? When did he consult with... When did he consult with his client? And why did the client not be shown that LPC letter?
Maybe there was no need at the time.
Hi guys, hi gang. Through the confession, it does appear that he is the suspect that was described as a tall, slender build which came into the house. Mncube, nicknamed Carlos. He is linked by means of sworn certified statements in the docket referred to herein and above. The involvement of this accused was equally explained in detail in the confession by suspect number 2 through the investigation of this information contained in the confession. Further evidence under the oath was obtained as to the suspect's real name depicted above. It was established that the suspect was a sentenced prisoner serving 35 years imprisonment for the murder committed in 2015. Ballistic tests revealed that the same firearm used in the murder for which the accused was serving his sentence were used in the murder of Senzo Meyiwa upon the accused's arrest for the 2015 convicted murder. A cell phone was seized in his possession. The cell phone downloadings were done, and the photos found showed him wearing the same clothing that were identified by the witnesses on the day of the incident as the accused carrying a revolver upon entering the house. Now, what's interesting about this firearm is that they are saying ballistic tests were done. Were they done after the testimonies of the ballistic experts and the Mangena is yet to come back, and his testimony is wishy-washy. So what ballistic test is Gininda talking about in this affidavit?
This affidavit has two problems for me. It sounds so old, yet so new. Do you understand?
Pela, after the testimonies, it should be combining. It should be like, oh,
Yes,
Mangena said
yes,
this.
yes.
Oh, this one said this. Oh, it should be flowing.
But we are still sitting on that revolver and the revolver going inside the house, and
jiggy, a pistol.
no clear indication whether the second person had a weapon or what. And then what we are hearing now, you would swear that he didn't have anything. He was just dealing with the phones.
And then between accused 1 and 3
And accused
now,
1 is said to have been holding a revolver. That's why I'm saying it's old, yet new.
oh my goodness. Between accused 1 and accused 3, who was the first intruder? Guys, yeah.
Between accused 1 and accused 3. No, we're talking about accused 2 and accused 3. We're no longer talking about accused 1.
No, I'm just asking generally because it seems like accused 1 is also somehow implicated.
An intruder of some sort.
Is an intruder.
Yeah.
And then now it's accused number 3 is also implicated. Number 3 is the description.
But it seems as
obviously.
if they have created now a new team of Danzi and Carlos. Yeah.
Accused number 3. Then where does that leave accused number 1?
Accused number 1 probably was also outside now.
He was bragging. He's the one who was doing the bragging.
Yes. He was the one bragging, I know. But,
So,
you know,
Imsha-
I guess he didn't even see what happened inside the house, right? He was just outside. If the theory of 2 intruders was to be anything that we go by, that means Danzi, according to their explanation, and the dreads guy, which is Tobisi, then these 2 would have been outside.
And he brags about
The one who was outside
Brags
checking if
about.
anyone is coming with maybe Mapisa, goes and brags about this thing.
that he's the one who did the crime. That he's the one who took Senzo. He brags about that before the announcements are made in the news. Yet he was not inside.
This
the
does not make sense because he's the one. Indeed, you are right. He's the one who brags such
Hi,
that
guys.
Gwabini now eventually or Zungu
finds
this thing out in the family gathering in hostel
Yes, and then he goes and snitch.
and goes and snitch. The guy that made this guy go out and do all that thing was not even part of the people in the house. Well, as it seems by now.
What a conundrum. The photos found showed him wearing the same clothing that were identified by witnesses on the day of the incident. This is Carlos, accused number 3. As the accused carrying a revolver upon entering the house, photos downloaded taken of himself or selfies matched the description of the one who had the firearm. Dreadlocks, big eyes with gold teeth. This is the suspect that went into the house, made a demand for cell phones and money. He's also the same suspect that shot the deceased in this matter during the struggle with him.
So that is accused number 3. Tobisi,
Yes.
Carlos Mncube.
Yes, photos were found of the murder weapon used in the murder of Senzo Meyiwa. They're talking about those
Many photos, some of
and
them.
those ones that were downloaded that were of firearms. Yes, Mthokozisi,
My killing machine.
my killing machine, yakhumbula. Mthokozisi Zipho Zonke Mapisa, also known as Mapisa. The suspect is linked to this offense by means of certified sworn statements and referred to herein above. He's linked by means of confession he made to a private person. A moment of silence
So Mthokozisi Mapisa now
is being linked.
commits crime. Then he creates this untrusted friend who's making sure that he's checking the coast for him while he's inside, right? And this friend snitch eventually. This friend goes and check, actually Zintanzi that he was checking on or he was checking on accused number 1.
Ntanzi, accused number
He
2.
checks on Tanz. Hey, Tanz is actually arrested. Now he's arrested for the 1, 2, 3. This case. Hey, this guy sends a message to Tanz. They say, hey, tell that guy to not include me. Because these people might actually take me out.
What a conundrum. What a conundrum. So he's linked by means of confession he made to a private person, a close friend, about his involvement in this matter. His confession came about in that the suspect requested this private person to establish why suspect Mafika was arrested. The information disclosed was that the suspect was not only arrested for ammunition, but also for the Meyiwa murder. And upon the private person return disclosing this information to the suspect, Mapisa instructed the private person to return and inform Mafika, who is accused number 2, not to disclose Mapisa's involvement, as he, Mafika, will be assassinated. So they are saying that he threatened Mafika as he found out that Mafika was making a confession. Mafika is accused number 2, Bongani Ntanzi. So he said that he found out that they are saying in this affidavit that accused number 4 found out that accused number 2 was going to be making a confession, and then he said that he will take him out if he includes him in his confession. When was all of this happening? You know, I'd like to know when were these threats happening and how they happened. Was it over the phone? Was it in direct contact? Because according to, from what I know, Mapisa was already incarcerated when Bongani Ntanzi was being arrested in 2020. So he was already in the jail. So how was it happening? Because after he was incarcerated, Bongani Ntanzi, they took away his phone, didn't they? So how did Kininda know, and how did he reach him? Because they are also in different prisons. It's all very interesting. I would love to know that. And it was during this discussion that Mapisa confessed. So they are saying because he was scared, Mapisa confessed to the private person his involvement in the matter. Investigations revealed that the role of this person was to guard any unexpected people who may come in or outside the house. He was also armed with a small firearm. Fisokuhle Ntuli, also known as Nkani, the suspect is linked by means of sworn statements by witnesses referred to above. He is linked to a car that was used as a gateway vehicle, which is a silver VW Polo. Evidence also revealed that he drove the car with the suspect to the same scene and back to Vosloorus hostel. After the incident, his role was to remain and guard the gateway car during the omission of the offense. The confession of Mafika, insofar as the usage of the vehicle refers to, is supported by independent witnesses, confirming that these accused was seen driving the said vehicle prior and after the committal of the murder in the company of the said suspect. The above suspects are also known to be hitmen for taxi wars. The said suspects were traced and found in different locations and occasions where they were warned according to their constitutional right in terms of Section 35 Act 108 of 1996. So Gininda read out this 3rd of October 2020 statement in court as per Ngome Zulu's request. However, he made a correction and said that the statement was actually signed on the 23rd of October 2020. So he was making yet another correction in the court with regard to the date. When can we say that this statement was made? It is written the 3rd, and
it was made maybe, I don't know, it could have been finished yesterday. Any day is possible.
Anything is possible.
Any day is possible.
So Bano reminded the court that it is a trial within a trial, warning Mncube Zulu on the cross-examination on the merits, and that it is on the admissibility of the confession. The judge said what Gininda has read is hearsay and not admissible, but he said that it must be read because Mncube Zulu insisted that their contents which rendered that application unlawful. So after the 15-minute break, Mngomezulu interrogated Gininda on accused number 1's arrest and the confession that he made. Gininda said that there was no need to charge Sibiya for Meyiwa's murder immediately after his confession. Gininda said he gave us information on who gave the instruction to kill Senzo Meyiwa. We couldn't just take that and charge him. We had to investigate. Mngomezulu asked, the investigations were ongoing while he was in custody, and Gininda said yes, they were, and rightfully so.
Welcome to South Africa, where now the person who's in charge, the president of this whole thing, if it was there, it's not charged. After the investigation of these people, they investigate, and they find whatever that they found. They arrest people. So they believe their theory. By arresting them, they believe the theory. Then where is the mastermind then?
Where is the mastermind?
What were you investigating? How did you find out then that these people should be arrested then? Because they are admitting, yes, according to your theory, where is the mastermind?
And who did they tell you that the mastermind is? And why is it not in their confession? Well, Gininda said that he did not make the confession freely and voluntarily is not true. The fact that Ntanzi and accused number 1 are saying that they did not make them freely and voluntarily is not true. He said, I asked him and he never mentioned that to me. He did it freely and voluntarily, and that is why the following day he continued with the pointings out of the traditional healer and so on. Well, after the long adjournment, Gininda said that he was not present during the pointing out of the traditional healer by accused number 1. Now the focus by Mngomezulu moved to accused number 2, Bongani Ntanzi, and Gininda confirmed that accused number 2 was arrested without a warrant of arrest on the 16th of June 2020, but argues the law allows for police to arrest without a warrant if there is a reasonable suspicion of crime.
What reasonable suspicions were those?
That after you go with him to his place, you find a black plastic bag.
We read that thing. It says that if you see one, these people were sangomas now, they could see through this.
And
people.
What is the crime that they were suspicious?
That's my question.
That they were finding him suspicious of, because they went all the way to his place and they found a black plastic bag. So what was the suspicion before you found that black plastic bag?
There was no suspicions, in all honesty, but well, there was. Let's please like the video, guys.
Please like the video.
488, 242. Come on, guys, have you forgotten how to press that like button?
So Gininda also confirmed that he was arrested for the Nongoma case on the 16th of June 2020. He said that he was okay, this is not a suspicion of crime. You were arresting him for the Nongoma case. You were not arresting him because you were suspicious.
By the way, that Nongoma case has 2 suspects, and they differ. The name differs.
They differ.
From Ntanzi's name.
Ntanzi is not there.
But somewhere, somehow, on this docket that was created in Joburg, the cold case unit capable of doing intelligence, they managed to have Ntanzi on it. According to the original one, Ntanzi is not there. It's 2 different people that have surnames and names. According to the new one, Ntanzi is there. And by the way, Nongoma case was done and dusted.
Yeah, it was. It was closed. The people that are implicated in the Wanyakwa Nongoma, they are incarcerated.
Yes.
They're serving their sentences.
Yes.
But somehow, somewhere,
they managed to find that person who's in custody, by the way, also.
Yes.
They managed to find him to come and say now, for some weird reason, Ntanzi was part of that.
Well, he said that he was taken to the Foslorus court on the 19th, but the matter was not enrolled. Gininda also confirmed that 2 suspects, Tabani Ngwenya and Qiniselani Buthelezi, are mentioned in the Nongoma docket. He agreed that the matter was finalized, but not in relation to accused number 2. He said that Buthelezi was found guilty in the matter. Advocate Mshololo said that since Gininda is testifying on the contents of the Nongoma case docket, copies of the docket should be made available to the defense. And Gininda earlier told the court that the docket could not be made available to the defense. So now there was that whole argument happening about the docket and the copy. Why ngafuna ukunikeza abantu amakhophi? Abantu amakhophi babone ukuthi ukhuluma ngani.
Because we predicted that it's not going to be easy to find the docket of Nongoma and have access on it.
So when you
based on the fact that already Ngomezulu had a piece of it through somewhere, somehow, I don't think they're going to be forthcoming when it comes to giving him the docket.
And remember how they had issues with that piece of paper. So when you approach the Boksburg court on that day, all 5 were in custody.
I think what is going to happen tomorrow is they're going to come with the charges. They're going to go and withdraw and draw those charges and say, this is what this person who was arrested in KZN was charged with. That's what's going to happen. You're not going to see a proper docket. Forget. Forget.
Well, Mncube basically was trying to argue that the warrants of arrest for the accused were not procedurally obtained. And on the 30th of May 2020, the first time you met CBI in Foslorus, you alleged that he made a confession and found someone to take the confession, and you knew where he was kept. So Mncube said when this application was brought, it was unlawfully obtained because these accused persons were already in prison. Okay. So he said, I'm requesting this. Okay. Guys, I think this is a wrap for me.
It is.
I am done with deliberating what had happened. I kept it short.
We did.
The second part.
And I'm hoping to keep this video short for now. I mean,
okay.
I don't think that unless someone calls now, we're going to take calls. I don't know.
Is the phone ringing?
Not yet. There's no ringing phone, so we're not shutting anyone down. But just because this is a beginning of this whole
we're still gonna have more lives, you guys. You know, this is a journey. This is a marathon. We take it step by step.
Yeah, the docket was set to be around. I think what we have established is that the docket we're referring to is the one that is resurrected from the old case, the original case. Let's say the original case docket. That's the one we're talking about. No way. I don't think it's going to be here.
Because they had issues with that one piece of paper.
I do not think it's going to be here.
That Mncube had.
Let's hear. I mean, I think someone has just decided to call.
Okay.
Let's hear what they say.
Okay, please don't hang up. We are connecting you right now. We want to hear what you guys have to say. I know I've been blabbing for such a long time. Give me a break, guys. Let's hear what you guys have to say. Let's hear what you have to say. So, is the sound on? Is it on?
Moleni Butini Dani.
How siyaphila ninjani?
Yes. Hey minyaka omthani avuya nibuyile udala nimkhumbula.
Hey besingela choice bekumele sibuye.
Kodwa lo nyaka simqale ngo higher grade nezi kushushu ngabe court.
Hey kushushu.
Okay, mama ndithi ndawubeka nje izinto zibe yi3 cha. Indawo uqala uNansika kubande lawyer namhlanje Mngomezulu.
Yebo.
Umbeke uratha ke endaweni yakhe. Noxoma zibuya ngaphakathi. Wathi wathula urata ne phansi kunento apha uNansika lo mjida uGininda la affidavit yakhe lena ibulele iNansika icase stage ayibulele but ibulele yayigqiba tu and kuneNansika kune question buyibuza nawe le ka mastermind bakutheni umastermind eNansika engabantu that was abantu fumanise base investigator bagqiba. You see everything banayo, then why umastermind engabanjwa? And then into endifuna uyibuza le nantsika le polo isilver ekabani le ihamba uzungu ukuthi
ipolo silver
yeah ipolo le isilver ukuthi adehamba ngayo labafana benantsika aba
bathe yafisa okuhle ntulu but hey bathe yafisa okuhle ntulu
ekabani network
bathe yakafisa okuhle ntulu accused number 5.
Why not drive ipolo that day because none can have in the polo.
Uchilo thi beka drive ipolo yamaphoyisa kwathiwa
Oh they drive motor maphoyisa.
Ushilo.
Okay. Man otherwise yeah man case nganiza kahle ama bayichithi case akho needs fire man wish you watch into engayaziyo le.
We need I can tell you now if we were to pull the records for that car they will tell us it didn't have what do you call that
AVL.
track AVL.
Yalahleka kudala kaloku kufana nedokete elidokete alizuvela nyansila akuvela dokete kunzima kwala dokete liya kula case yasenantsika zasukwazi ngoba thatha ngamadokete amathathu kunyansilwa bawucreator ngoba amadokete but I don't think izawusebenza loo nto leyo.
That's true.
Okay man ndiyekela abanye but enkosi man ndiyavuya nibuyile bendinikhumbula kudala nimanje nijonga nolapha kuDecember.
Thank you.
Okay, thanks guys.
Yay! Kade ngikhumbule nami shem. Yo, lives are something else. I love lives, Mr. Anonymous.
You love life.
I love life.
Seyivala. Seyiqopha lezo zinto.
Sizobuya kusasa.
Sasa it's a big day. We just wanted to jog your memory properly so that you understand what is going on. We are still going to deliberate on that wishy-washy way of dealing with things when it comes to that case of is it Muzi?
Moses B.
I've never seen such, but it's okay.
We haven't unpacked it.
Yeah, but look, the main aim is not to defend, but we must say it as it is. If it doesn't make sense, it does not make sense.
It doesn't. If it doesn't make sense, it doesn't make sense. If the glove won't fit, you must acquit. O.J. Simpson trial.
Zanzelo.
Mr. Anonymous.
Yes, sir.
How are you?
We're good. How are you?
Good. Emily, compliments and Mr. Anonymous.
Thank you.
Thank you.
Mr. Anonymous, my man, Mr. Kininda is frustrating me. With these long answers that don't make sense. Like, really, I don't really understand what is this man saying. Honestly speaking, I don't. I was just saying to myself.
He's smart, remember.
Why can't... he's not smart anymore. He has never been smart. And you know, this... and this issue of I remember watching a cast from Lelo and this issue of the what you call the affidavit or the collapsing the state and everything. I think it might be the same issue that he was talking about Chichi Tobani. He was maybe referring to this affidavit. Because really, the affidavit doesn't really make sense. It doesn't. When you try to read it, it doesn't really make sense. And another thing is this issue of they're trying to shy away from this thing of applying for a J50 while the person is arrested. Yes, there's no law that says you can't apply for J50, but why would you go to an extent of applying for J50 whereas the person is already incarcerated?
Yes.
Because that means to get a J50, it's a long process. Why would you take a process that is long whereas somebody is already incarcerated? So I think what Gomezulu was hammering on, it was correct because of it doesn't really make sense. Why would I enforce a person to be arrested whereas they are arrested?
Because these
So
people,
it
what he
doesn't-
was trying to show is that these people were actually arrested for Senzo's thing, not the other stuff. The other
Yeah.
stuff they just made up stuff allegedly to cover for the loopholes of doing Senzo's case this way.
Yeah, but I know, I understand what he was trying to, like, he was trying to narrate that picture to us, that these people have been arrested for this Senzo case, were arrested for these cases that are not related to Senzo, but they should be arrested for Senzo case. That's what I'm trying to get, trying to understand what you're saying, Mr. Nimas. But it doesn't really make sense. And another thing is, when you look at when Kininda took over the case, you are right, Emilio, say there was no investigation that was done there.
No.
There was no investigation. I think they just took the case and rushed so that it can reach the what you call the NDPP's office, so that they can push the case. Because of, honestly speaking, already today's affidavit that Zungu was reading is cancelling the evidence of Lorraine, it's cancelling the evidence of Mtogo, it's cancelling the evidence of Tumelo.
Yay.
It's cancelling everybody's evidence. It's a now new thing. And that cell phone thing, the cell phone was captured by what you call that man who said he was tired, Warrant Officer Musia. The cell phone was captured in one of the photos. Even Mumalo Disc did ask that on those photos, if you zoom in, don't you see an S4 Samsung, which was black in color? And the Honorable Judge Rata said, yeah, but that could be any other S4. You see. So I think this case, Hashem, if I was Andrew Chauke, I would be ashamed. I'm sorry to say that. If I was Andrew Chauke, I was going to be ashamed. There's no case here. It's just a waste of time. Maybe they should try 375.
Yeah.
There's no case here.
Yeah, honestly.
There is no case.
Come to the front.
Yeah, exactly. There's no case here. There's no case. Even the star witness that we thought is going to say something that has sense. Even when I almost laughed when Judge Rata said, when Kininda was reading the evidence, he said, it's a hearsay. It's a hearsay. There's no even tangible evidence. There's no a proper chain of events. Yes, they tried to create a proper chain of, but there's no chain event. There's actually nothing, guys. There's nothing on this case. Nothing at all. The case must just collapse. They might try to find something else to do.
Yes.
Honestly speaking.
I agree.
Because there's no, I mean, when you listen to that evidence, Kininda is explaining a whole lot of things. It's being asked some good question. Subsequently, wara, this and like, this man, is not, Mr. Subsequently, is not subsequently, unfortunately.
No.
So anyway, guys, we'll see what tomorrow, but the dockets are not coming, Hashem. The dockets, Shem, forget.
They're not coming.
The dockets, they're not coming. But when KZN police, they don't play games, Baba. They can't be wasting time on stupid things. They've got to deal with political killing. They've got to deal with taxi violence. They've got to deal with all lot of things. They can't be wasting time on dockets that are not making sense.
Yeah, that's true.
That's my take, especially if you're referring to Nongoma. You know, if you've watched the videos of that other guy, who's that guy?
The guy who's always telling it the way it is, who's part of the police, was telling Begiceleto not to. What did he say?
He said something like that, yeah. Because
who is that?
you can't be wasting time on those things.
The guy.
And another thing is like,
you remember the unrest?
Oh,
Yeah, that
there.
guy.
yes.
That guy tells
Mkwanazi.
name Mkwanazi.
Mkwanazi.
Mkwanazi doesn't.
History.
You see, the one thing I like about KZN police officers, I'm not saying Joburg officers are not that hardworking, but KZN officers, they put a lot of work, they put a lot of effort in what they're doing because of they know that they have to deal with serious issues. Serious issues. I'm telling you, you'll see the non-government docket, it won't come, or whatever dockets, they won't come. Because of those people are not there to entertain stupidity or mediocre. They are there to work. So I don't see Kininda coming with those dockets unless if they've tried to make what you call dummy. I'll use the word dummy dockets. Because of obviously they have got the information that they can extract from the case, from the SAPS system. They can try and manipulate or whatever, but those dockets are not coming. And one thing I know, I've noticed about the SAPS in KZN, when they're done with the case, they're done with it. They're not going back. They're not telling you, it's either they drop the case or they continue with it. They don't play games of resurrecting cases. Yeah. So, guys, let's see tomorrow what will happen. I think, again, if I were to be Gomezula, I would also apply for that, what's it called, section 143 or
yes.
175, something like that. I know there's that. He must continue with that application.
Yeah, he mustn't abandon
He must.
it. He must.
Yeah, he mustn't abandon it. He mustn't abandon because of guys. There's no case here, my man. There's no case. And you know, another thing is, I wish we can get that lady. What's his name? The one of sister of accused number 4, Sinobile. Maybe he might be able to narrate us what really happened because of what Kininda is saying. I don't really get it. But I've listened to a clip on YouTube about how the guys were arrested and implicated. What Kininda is saying is totally different from that other lady's clip. So there's no case, guys. Let's rest it. Let's put it to rest. Let's put it to rest.
Thank you.
So anyway, guys,
man. Let's just shut down. I think it's time for us to shut down.
Yeah, let's shut it down, guys. We'll see you tomorrow.
Yeah, yes. Thank you so much for calling. And until
Thank
tomorrow,
you, guys. Have a good evening.
Yeah, good evening. Actually, good morning. So, guys, we are wrapping it up. Thank you so much for joining us. And those who will be catching up in the morning, hi, we are back. Bye.